Trigger warning for gratuitous use of Latin. But I have some questions for you. When it comes to actually judging cases, are judges experts? Well, as far as the law's concerned, no, they aren't. Can you be, quotes, tried twice for the same offence? Yes, you can. What happens if in two trials you come to different conclusions? What happens then? So what am I talking about? Well, I'm going to talk about something called res judicata, but also the interface of criminal proceedings and civil proceedings, because someone's actually asked me to address this. Also, it's sort of related to that case with the MMA fighter in Ireland, where a woman brought a civil claim against him alleging certain offences, and he was found liable and has to pay her just shy of €250,000, even though there's been no criminal trial. So what I'll do is I'll start with the sort of civil aspects, okay? What is res judicata? Well, res judicata is the idea that there needs to be finality in cases. So once a court has ruled on an issue, then generally speaking, subject to appeals and things like that, you can't have a second bite at the cherry. You can't keep sort of bringing further cases. And we talk about cause of action estoppel and issue estoppel. So what's cause of action estoppel? And again, I've got some notes here. Well, it's basically that a party can't reopen a matter that's already been determined in earlier proceedings. It stops somebody relitigating the same cause of action, and it's an absolute bar, except in cases such as fraud. Because as we all say, fraud vitiates everything. But that's a very high bar to prove. But say, for instance, you bring a claim and you lose that claim. Sorry, we've still got storm bursts. We keep losing the electricity. You lose that claim and you have all your appeals and everything, but they say, no, we're going to stick with that. And you're going, well, hang on, this is all lies and this is all everybody perjured themselves. I mean, what can you do in that situation? Well, if the judge just doesn't accept that, there's not too much you can do. But what if down the line you actually find evidence and say, this was a fraud from the start. We can now prove, and here's evidence that wasn't reasonably available to us originally, that shows actually it was all a con. Well, then actually you can bring an action in fraud and you can say, but for you committing this fraud and effectively lying in court and perverting the course of justice, the result would have been different. So what's my losses? Well, it's the fact that you lost out on your claim. So, that could be a head of damages. We would have won, but for your fraud. It works the other way as well if you're defending a claim. But it's all your legal expenses. It's any other expenses. But you have to be careful with fraud. I mean, a lot of the time people will get quite vexatious about this because, they'll appeal and they get knocked back. They'll try to bring private prosecutions. I mean, witnesses in legal proceedings have absolute immunity. So they, generally speaking, cannot be sued for anything. So you can't sue somebody and say, you committed perjury or you committed defamation or you were lying. It's like tough. That has to all be dealt with in the proceedings. But, the only way you can be dealt with there is, perjury and things like that. They're criminal offences. But again, to stop people just harassing witnesses just because they've lost a case, then you can only bring a private prosecution for perjury with the consent of the Attorney General, which is rarely forthcoming. The idea being that, yes, the state has an interest in sort of making sure proceedings are fair, but it's not a personal right of action. And also, you've got to be careful if you do bring a fraud claim, because now I've said, fraud vitiates everything. Oh, brilliant, I'll just sue for fraud if I lose then. Well, no, because again, bring a private prosecution for fraud. The court will say, well, actually, this is just, the fraud is that you're saying people perjured themselves and perverted the course of justice. And again, you can't bring a private prosecution without the consent of the Attorney General. So it doesn't matter what label you put on it, you're fairly stuffed. Also, to get back to the principles, if you sue and you're successful and you receive damages, you can't actually then bring a further claim for further damages. And that's related to something called the rule in Henderson that I'll mention in a second. But you've got to basically do it all in one go. So you can't say, I'm going to sue you for negligence and these are the losses I claim. And you win. And you go, actually, thinking about it, not only did your negligent work mean my factory wasn't ready on time, so I'm suing you because, you did negligent work and, you didn't actually get my factory up and running. Oh, actually, I've just realised there's all the loss of profit stuff. I'll sue you for that. It's like, no, you should have done that actually at the same time. There's also something called the doctrine of merger. That's very technical. But that just treats a cause of action as extinguished once judgment's been given upon it, and the claimant's sole right as being a right upon the judgment. So that basically produces the same effect as the previous ones. It's just a sort of like slightly different way of describing it. Now, issue estoppel. That is where parties raise issues, actual factual issues, or even legal issues, but mainly factual issues in court cases, and the judge, as part of their ruling, they say, well, I find, as a matter of fact, this is what happened. Well, that is binding on the parties. You can't, in future cases, try and re-argue a different factual position, but, and we'll come on to this only actually binds the parties. And there's also something called the rule in Henderson, which basically means if you've got a series of claims against somebody, you should bring them all at once. You can't sort of bring them piecemeal and willy-nilly and sort of go, well, I'll sue you for this, then I'll sue you for this, then I'll sue you for this. It's not an absolute rule, but generally speaking, say you're in a car accident and you bring a claim, you say, I'm suing you for the damage to my car. But then also you go, actually, I've also got a bit of whiplash. You've got to bring those together, generally speaking. The idea is that all claims should be tried together if it's more convenient and if you'll be covering the same ground. It's not an absolute bar, though. There may be situations where a court agrees and says, look, you have a number of potential causes of action and legit claims against this defendant, but they are so, they're so separate and they don't arise necessarily out of the same facts. So therefore, it might be more convenient not to actually lump them together. But what about this thing about the judges being experts? Well, when a judge decides a case, they're just expressing their opinion, aren't they? They're just saying, in my opinion, I have found that the evidence supports this case, and I have found on the balance of probabilities, or whatever the requisite test is, that this is the factual situation. But that's just a judge's opinion. So say you want to refer to that in a different case. Well, the rule is that opinion evidence is not admissible in legal proceedings unless it's evidence coming from an expert. And what the court say is, actually, judges aren't particularly experts at deciding things and finding facts. And it's the same for juries. If a jury returns a verdict, well, it's just the opinion of 12 good men and women of true. So it's not actually binding on anybody. And this is why you can have parallel criminal and civil proceedings. So say, for instance, somebody commits an offence against you. Let's just call, let's say assault or something like that. Well, most criminal offences have civil analogues. Sometimes they have the same name. Like you can be prosecuted for fraud. You can also bring a claim in fraud. We have various types of criminal offences that amount to assault. I mean, we've got common assault, but then we have assault occasioning actual bodily harm, assault occasioning grievous bodily harm, and assault is a cause of action in civil claims. Sometimes we use different names, though. So theft is the criminal offence, but in civil proceedings, we tend to call that something like conversion or trespass to goods. But the idea is that they are separate proceedings, because the thing to remember is, in criminal proceedings, the victim is not a party to the proceedings. They are just a witness. Criminal proceedings are for the benefit of the public, for the state. The idea is that, His Majesty does not want his subjects fighting outside His Majesty's kebab shops on a Friday evening, because that's just not in the public interest to allow that. So we penalise that. But we call witnesses. I mean, this is the thing, and this is why even when, complainants, to use the neutral term, as a general rule, if an offence hasn't been established, if the issue is, did this offence take place, they're the complainant. If there's no dispute that an offence did take place, but we're just not sure who did it, then you can actually call them the victim. But at this stage, they're just the complainant. So they can actually be summoned to court themselves. You might get someone to say, I don't want to get involved in this. Well, theoretically, they can be witness summons. They can be compelled. I mean, this was a big issue in DV type cases because obviously people would lean on complainants in cases. And we used to joke about this when we had DV cases back in the day, because it would all start off and then the judge would say something like, shall we allow 4 weeks for the withdrawal statement? Because, it was so common for that to happen. So what did they do? Well, they said, well, okay, we'll start compelling people to come to court. But then you get the situation where people were just too terrified to actually give evidence against people because they've been lent on. But then they would be prosecuted for contempt of court for not abiding by the witness summons. So you'd end up with them going to prison instead of the person who may have actually committed the offence. Obviously, that was very unsatisfactory. So now the procedure is that they will just put the complainant's evidence in as some sort of hearsay. It's like, well, yes, they did originally make a witness statement and we'll put the witness statement in. Or even they reported to the police, but then they didn't want to cooperate. Because you can actually put hearsay in criminal proceedings subject to applications. I mean, the problem there is that it's very easy to make the argument and say, look, they're not here, this evidence hasn't been tested in cross-examination, and it does make convictions very, very difficult. But that's, like I say, that's something you've got to remember is that in criminal proceedings, it's the state is the party and the defendant. But let's say, there's an assault case. Well, if you sue the person who assaulted you, or you say assaulted, then you are a party to the case. So, that all the decisions are between you and they're binding on you. But what, like, say, okay, so somebody is, a prosecution is brought, and the person is acquitted. It's a not guilty verdict. Or the authorities just refuse to prosecute. Well, you can still bring a civil claim, and people have done that, and that's what this last did. And now remember, of course, the burden of proof in a civil claim is lower. It is on the balance of probabilities, as we say, as opposed to so that you are sure, stroke, beyond reasonable doubt in a criminal case. So it's actually easier to prove. But one thing to remember is the law is binary. There is no procedure in law for a verdict of, well, maybe. And a judge can't come back and say, well, maybe this happened, maybe this didn't. Once the threshold is crossed and you have got past the standard of proof, so a judge finds on the balance of probabilities, this is what actually happened. And that can be 51%, 49%. But as far as the law's concerned, that is now a factual state of affairs. It's not sort of, well, we've only just found it, but it's it's still open to interpretation. The law says, no, those are now the facts. And in fact, in some family proceedings where it's allegations of, like, say, assault against children and things, the threshold is actually a bit lower because it's only sort of, is there grounds for suspecting this and is there grounds for... So theoretically, the actual standard is lower. Now, when it comes to allegations in civil proceedings of things that are criminal offences, it used to be said that although the burden of proof and the standard of proof remain the same, the proof is on the burden is on the claimant, he who asserts must prove, and the standard is, balance of probabilities. They used to say that actually, if it's an allegation of criminal stuff, although the standard's the same, you might need more evidence to meet it. And the example they always give is, if I say I saw a dog in Regent's Park, you might need less evidence to believe that than if I said I saw a lion walking around Regent's Park. But there has been a recent case that said, well, actually, no, because there's nothing, the idea used to be, well, people generally speaking don't commit crimes, so you need more evidence that they did. But the courts come back and said, like, people commit crimes all the time. So what's special about alleging somebody committed a crime as opposed to saying, somebody was like a negligent builder? So now it actually, the evidence you need, there's no sort of special rules saying you need more evidence to prove a criminal case. But that's what can happen. So you could have an acquittal or, not even be prosecuted in the criminal cause, but you could still succeed in a civil court. Similarly, though, what happens, can it work the other way around? Could you have a conviction in a Crown Court? So let's say you have a conviction in the Crown Court and you say, right, I'm going to now sue the person. And you say, well, they must have done it because the jury found they did it. Well, like I say, jurors are just, lay people, and the verdict is their opinion. So, you can actually put in a certificate of conviction, and that is that's prima facie evidence they did it. But it is still all up for grabs. It's not definitive. It's just like, well, this jury said this. However, you can challenge that. Now, again, you've got to be careful here, because to go back to this idea of finality, courts don't like collateral attacks on things. But generally speaking, you are allowed to defend a civil claim even if you've been convicted in the Crown Court. There was a notorious case, actually Lord Denning. It was actually the Birmingham Six. And they brought a case saying, we're not challenging the verdicts, we want to sue the police for beating us up to get the confessions. And Denning said, well, no, this is a collateral attack, because although you're not challenging your convictions, obviously if we find you were beaten up and tortured to get these confessions, that will throw doubt on the criminal convictions, and it would be absolutely abhorrent to do that, because then people wouldn't trust the police, and we can't have people not trusting the police because society will collapse. But like I say, that theoretically then, so you could be convicted and still defend a civil claim. So you can get different results. But what's it, to come back to this expert thing, what if you want to say, well, I'm suing somebody and I'm going to be arguing some facts, but in another case, a judge has already ruled on these facts. Well, if it's the same parties, or what we call their proxies, so even if they're not identical in the way they're named, but effectively, they are the same party. That could be a situation where a director has had a case and then the company brings a case or something like that. Or if you've got trustees or guardians and things like that, then it's binding on the actual parties, but it's not binding on anybody else. And this is what I come to, because even though judges ruled, judges are not experts on making decisions. So the mere fact that a judge has ruled on a finding of fact in one case, it's not actually evidence in any other case, because it's just inadmissible opinion evidence. So you can actually, basically, it doesn't matter if a judge has ruled, even if it's the same judge, and to go back to an example, like I said, this is, this issue estoppel thing. I mean, to go back to that case, that Depp and Herd thing, there was an argument, because in the American trial they said, Amber Heard's team said, we're raising issue estoppel and res judicata and cause of action, because the English court has already found Mr. Depp to be liable for these offences. But in the English case, the parties were Johnny Depp and the Sun newspaper and a journalist. And Amber Heard made it very clear, she said, I am not a witness in this case, because when they went for third-party disclosure, her argument was, I'm not a party to this case, I am just a witness. So they couldn't get third-party disclosure. But when in the States, they said, well, yeah, but you're now trying to raise issue estoppel, but that only binds the parties, and you explicitly said, in the English case, you were not a party to the case, and therefore this is all up for grabs again. Because like I say, the principle does apply. Courts will actually look. So say, for instance, two parties had sued each other in one jurisdiction and got a result, and then the party tries to bring a claim in another jurisdiction. Well, that can be struck out for lots of reasons. We have all this forum non-convenience and stuff. Where's the most convenient place to have the trial? But most courts will agree that if you've had a trial in one jurisdiction, the same parties can't have a trial in a different jurisdiction. But they will actually also do it on the basis of, anyway, we've got all the issue estoppel and cause of action estoppel points as well. But sometimes that happens, and you do end up with inconsistent verdicts. I mean, the courts generally don't like inconsistent verdicts, and that's why they have these rules about you can only have one trial and, pick a jurisdiction. There might be lots of places you can sue. The example we got at bar school was quite an interesting one, was an English bloke on holiday in the French side of the Alps throws a snowball across into the Italian side of the Alps and hits a German guy. Where does the German guy sue? Which jurisdiction? And it's pretty much, actually, you can argue that you could sue in France, Italy, England, or Germany, because it all depends, where did the tort actually happen? Where are the parties habitually resident, and all this sort of thing? So it does all get quite interesting. But yeah, I mean, I think a lot of people would be surprised about that idea that judges aren't experts on judging as far as the law is concerned. But I hope this explains also, like I say, why then you can have parallel criminal and civil proceedings and why they can quite often come to different conclusions. So there you go. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. And like I say, I'm back indoors today because we've got this storm burst. I'm just recording this very quickly. Well, I've actually got some electricity for the lights. And as always, the boys say hello. I should have done this. Should have said like, Mr. Viewer, we've been expecting you. We just swing round in one of those old 1960s swivel chairs. And I've just realised I'm covering the microphone up there.